Well, good morning and welcome to the November docket of the Kansas Court of Appeals. For those who may not know me, my name is David Bruns, and it's my pleasure to preside over this illustrious panel this morning. With me on my left on the screen, I don't know how he appears on your screen, is the longest serving judge on the Kansas Court of Appeals, the Honorable Henry Green. And then on my right, as I'm looking at the screen, is one of the newest judges on the Kansas Court of Appeals who joined us earlier in 2021, thanks to the governor appointing her and the Kansas Senate confirming her. We're so happy to have Judge Leslie Isherwood with us. And as you may know, she had an illustrious career for many years as a member of the Sedgwick County District Attorney's Office. Today, we have two cases on the docket. The first case is Perez et al. Versus Wesley Medical Center. This is a medical malpractice wrongful death case. I would ask the counsel state their appearances for the record.
Brad Prochaska for the plaintiff appellant.
And Andrew Marino for Wesley Medical Center.
Good morning.
Morning.
As counsel knows, each side has 15 minutes to argue, and Mr. Prochaska has advised me before we began that he would like to reserve 3 minutes for rebuttal. And as I'm sure you also know, we have been provided a lot of documents in this case. And we've been provided with pre-hearing memos by research attorneys, additional research. We've reviewed, I won't say we read all of the record because it is voluminous, but we have read a large portion of at least the material parts of the record. So I would encourage you to really get to the issues and see what the judges are interested in on the questions that they may ask. With that, Mr. Prochaska, you may begin.
Thanks, Judge. So it's the plaintiff's position that we met the causation burden two ways. First way was we had a standard of care opinion. And then the second way, we had all the facts and inferences. I want to talk about the trial court's really bad, humongous error on the facts and the inferences, because the trial court focused on a false premise that Dr. Bender got a full report of pulmonary edema symptoms at the 8:34 phone call. I want to emphasize that because it's on volume 3, page 23. I'm going to read to you the trial court's two sentences, and then I'm going to prove to you how that is a falsehood that the trial court based its entire usurpation of the role of the jury on. Quote, "The problem for plaintiffs is what happened after the 8:34 a.m. phone call. Dr. Bender had a full report at 8:34 a.m. showing Lindsay had significantly more pronounced symptoms of pulmonary edema, but Dr. Bender did not immediately order Lasix from that 8:34 a.m. report." What the trial court is saying to throw out the jury's verdict is, if Dr. Bender had a full report at 8:34 a.m., then and did not order a Lasix, then if she got a full report an hour earlier, she wouldn't have ordered Lasix again. Nothing could be further than the truth about this full report. I told the court, the appellate court, I'm going to prove to you there wasn't a full report by any stretch, okay? And I'm just going to show you volume 23, page 18 of the clinical note of Dr. Bender typed minutes after this erroneously, supposedly full report. I'm going to read to you one sentence, okay? This is a sentence Dr. Bender typed. "Called by RN again at 8:34 for persistent severe range blood pressures and a patient with crackles on lung exam." Okay. Where is the pitting edema? Where is the breathing problems? Where is the decreased oxygen levels? Where is a nurse? Where is it recorded that the nurse told her there's lots of symptoms of pulmonary edema? Where is the report from the nurse that there was a serious fluid overload of 12 cans of pop, a volume of 12 cans of pop, which tells the doctor that fluid's going into the lungs. We held up 2 6-packs on display the entire 2 weeks. Now, that is such a false premise. And I want to point out that the trial court emphasized that full report. Defendants in their brief quoted that same sentence from the trial court I read to you. And what is really outrageous is neither of them, the trial court had 4 months, the defense had 2 years. Neither of them cited a single medical record, any deposition testimony, and no trial testimony to support that completely false premise. If you go to the nurse note, Van Epps, who called at that 8:30 phone call, volume 23, page 35, she says, patient experienced respiratory distress, increased respiratory distress. Where are all the symptoms of pulmonary edema again? Where is the fluid overload? Where is the pitting edema? Where's the nurse saying, I told the doctor this patient has pulmonary edema symptoms and maybe we should order Lasix? None of that is in evidence, zero. And to make this erroneous finding of the court so clear, the trial court, a few sentences later, after saying that she had supposedly this full report, the trial court writes that it was, quote, uncontroverted evidence. There's no evidence whatsoever of it. In fact, the exact opposite is true. It was a completely inadequate report. The jury found that, and the trial court takes away the jury verdict on a completely falsehood with no evidence whatsoever cited anywhere in the record and calls it uncontroverted, a humongous error. So just to repeat, the court usurps the role of the jury, finds a fact that isn't a fact whatsoever, and then calls it uncontroverted evidence when it's really uncontroverted. A completely inadequate report was given. That
Mr.
is
Prochaska, Mr. Prochaska, let's follow up on that a little bit about what happened at trial. I mean, I recognize the order to set aside the verdict subsequently. Evidently, there was a motion for a judgment in a matter of law that was just taken under advisement. It appears from the record that the plaintiffs were attempting to introduce causation evidence to establish the causal chain and the links between the alleged malpractice that you've just spoke about and the death of Ms. Perez. And it looks like you were, well, or counsel, I don't know who was asking the questions at the time, was cut off. Can you tell us a little bit about that?
Are you referring to the standard of care opinion?
Well, it looked to me there was an attempt being made to establish causation, but the word standard of care was used. I don't know if it was Mr. Marino or who said, excuse me. And the district court said, oh, you said standard of care, and basically cut off what appeared to be causation evidence.
I would love to talk about that. First of all, I'm going to read to you the sentence that the world authority, Dr. Sabai, stated, which is a causation connection opinion. He said, all of them, if you are suspicious of pulmonary edema, you give the Lasix and then call for help, because you have to get the Lasix if there is a suspicion of pulmonary edema. So yeah, that's kind of, and cut off. Now, what I just read to the court, that's in evidence, it's a standard of care opinion. The causal link is there. I don't have to ask the question, is that the standard of care? Nunes v. Wilson says, I don't need those magic words. There is no way to interpret that sentence. You have to get the Lasix. You give the Lasix. There's no other way to interpret that other than a standard of care opinion. Now, when I asked, is that the standard of care? And they objected, and the court erroneously sided with them. There was no motion to strike that answer, no admonishment of the jury to disregard that answer. So the answer again is in evidence. So the first answer is in evidence. The second answer is still in evidence. So we twice had the causal link in evidence. And when I say the causal link of the standard of care opinion, I'm going to read to you what's in defendant's brief, because they admit that was the causal link. Defendants say on volume 11, page 47, Dr. Sabai's standard of care opinion, quote, is absolutely linchpin testimony to provide causation. That's what they say. So we have that opinion in twice. We have the causal connection. The court again made a humongous error in taking away the fact finding of the jury. And so we have both the factual evidence and inferences, and we have the standard of care opinion. I also want to mention that the trial court said the only possible inference that can be made is Lasix wouldn't have been given because it wasn't given at the 8:30 phone call with this allegedly, ridiculously alleged full report. There's lots of inferences that can be made, especially the inferences from Dr. Sabai and Briel. They were the only clinicians, the only obstetrician, and the only cardiologist that testified. There was 2 weeks of evidence from them that you got to give the Lasix. Uncontroverted, because the defense couldn't find an obstetrician or cardiologist to come to court. So we had all of that evidence, and then the trial court usurps the role of the jury and takes away the verdict. So I'm asking the appellate court, please preserve the right to a trial by jury and reinstate the verdict, because otherwise this case will be used as a precedent to find false facts, make humongous errors, and throw out verdicts.
Well, let's talk a little bit about the potential remedies if we do agree with you. First of all, if we were to reinstate the verdict, what verdict would we reinstate? It appears to me that another thing that was done in between the jury trial and before the motion of judgment as a matter of law was granted, that the judgment was reduced. Now, if I read it correctly, it appeared to me that it was reduced just to make it consistent with the pretrial order. But can you explain a little bit what happened there and what your position is?
Sure. Of course, the defense wants it reduced, but I'm going to give you my brief argument, and there's 3 arguments. First of all, in my closing argument, I told the jury, you can award more than what I asked for. There was no objection. The defense waived all of their objections to increasing the verdict beyond what I suggested in the pretrial order. It's been waived. You have to object. Second of all, as we know now, the plaintiff has a constitutional right to trial by jury to determine damages, which they did. Third of all, the defense alleged, well, there's some kind of prejudice by me asking for more money than the pretrial order. They wouldn't have tried their case 1 iota different. They haven't pointed out anywhere where they would have done anything different. And that makes sense. If I ask for 4 million or 5 million, what are they going to do differently? So my bottom line is the damages should be just what the jury awarded, because the plaintiff has the right to have the jury determine damages. They waive their objection. They cannot be heard to object the first time on appeal. And there's no prejudice anyhow. They tried their case the exact same way they would have, no matter what kind of money I would ask for.
And then the final question that I had was, and we really need to look into the transcript on what happened, what was cut off, what was in your expert report that didn't get into evidence. Is there enough there? I know your position is there still was enough for causation. But let's say we find, which your brief says, that it was clear error for the judge to not allow the rest of that causation evidence to come in, and we don't reinstate the verdict at whatever level. Would the appropriate remedy there be to order a new trial?
Well, you don't get a do-over just because you don't like the result. They have to tell the appellate court why they're entitled to one. I'm looking at their 2 or 3 sentences on page 47 of the brief. They give no explanation why they want a new trial, why one is entitled under the law, or why one is entitled under the facts. So I'm going to tell you why one is not entitled, okay? First of all, they invited the heir to object to the admission of the standard of care testimony. You can't invite heir and then profit from it. We know that's the law. You just can't go. They invited it, they got what they wanted, and now they're screaming that they need a new trial. Second of all, we don't even need that causation testimony on the standard of care. We have plenty of reasons for the verdict to be reinstated based on the facts and the inferences and the unfounded, horrible error of finding a full report at 8:30. So there's another reason why the verdict should be reinstated, which is the facts and the inferences. Third of all, the defense failed to preserve their right to ask for a new trial at the trial court level. They never asked the trial court for a ruling on their new trial, so they waived that. They haven't preserved it on appeal in their docketing statement or cross appeal, so they waived their right to request a new trial on appeal. And finally, in spite of the humongous errors of the trial court, the plaintiff still got a verdict on all of the issues from the jury, in particular on the facts and the inferences. So we've already had a proper resolving of the issues and support of the verdict on the facts and inferences. So it's harmless error, if there was any, which there wasn't, on excluding the standard of care opinion. Why would you give a new trial when the verdicts are supported otherwise from the facts and the inferences?
Mr. Prochaska, you're at your 12 minutes now, or maybe a little bit over. So I'm going to just see if either Judge Green or Judge Isherwood have any questions they want to ask at this point. And if not, we'll turn it over to Mr. Marine.
One thing I like to ask about instruction number 4. And basically instruction number 4 said, had Nurse Van Epps met the standard of care by properly and improperly communicating that Lindsay Perez signs and symptoms of indicative of pulmonary edema. And then this is a phrase, to any physician. I mean, it's not, how can you say, narrowed down to this Bender. This says any physician. Can you tell me how does this play in this particular case as far as saying that your action, as far as what the trial court did is taking this verdict away, should be reinstated?
You've read that correctly, Judge. And the reason why that's so correct is because the expert disclosure from Dr. Sabai, I'm going to read it to you because it doesn't focus on Bender. It is a correct statement of fact that had she disclosed that to any doctor, the standard of care would be to give the Lasix. That was disclosed, and I'm going to read to you that sentence, which is volume 8, page 17. Quote, had either nurse communicated their findings suggestive of pulmonary edema, the standard of care would have required treatment be started, and said treatment would have saved Lindsay's life. Nowhere in that sentence, that expert disclosure by Dr. Sabai, does he focus on it has to be Dr. Bender. She could have communicated it to any of 2 or 3 different doctors, and the standard of care is to give the Lasix. It saves her life.
Just to follow up on that, though, isn't that the evidence that you weren't able to get in because you were cut off? I mean, it's in the report, but I didn't see it in the transcript. Did it ever make it into the record? I know the report was not admitted.
Well,
because it does seem like Judge Woolley, even in his order to set aside, with his attention somehow got to diverted with what Dr. Bender would do. And as Judge Green just pointed out, and I think you agree too, that's not what we're talking about here. It's what would any reasonable OBGYN do in this setting. She happened to be a 3rd-year resident. He seemed to get hung up on that, but I think practicing obstetrics and gynecology, she would be held to the standard of an OBGYN. So did that make it into the record?
That particular sentence did not make it into the record, no matter how many times I showed it to the trial court. But a very close sentence did make it in. I'll just read it to you because it's brief. This is Dr. Sabai's answer before the standard of care objection. All of them said, if you are suspicious, and by the way, suspicious means you don't have to diagnose pulmonary edema, just suspicious. if you are suspicious of pulmonary edema, you give the Lasix and then call for help, because you have to get the Lasix if there is a suspicion of pulmonary edema. So yeah, that's kind of, that sentence again doesn't focus on Dr. Bender. That's the standard of care for any physician. That nurse could have talked and called any physician and they give the Lasix. That's the standard of care. And then Lindsay lives.
What about the question just before what you referred to? And the question was, would you tell the jury if a resident in the third year is told about the symptoms of pulmonary edema, do they have enough knowledge at the third year to order Lasix?
And that's why I put that in purposely in that question, because Dr. Bender was a third year. So if a third year knows that that's the standard of care, certainly a full-fledged doctor knows. So that's kind of an irrelevant point, because even if a third year knows, then any doctor knows to give it. And that was just to tell the jury, don't be given an excuse to the defense that Dr. Bender was a third year. That standard applies to her too. They have enough knowledge.
And just
And
so
that
it's
kinda
clear,
goes-
she was, go ahead, Judge Green.
But that goes back to your instruction 4 that was giving and talking about any physician, right?
Any physician, she's a physician as the third year. She's a physician 3 years ago.
Right, she's just not board certified yet well,
Yes.
at that time, now she is, I'm sure, as an OBGYN, but she would have been held to the standard of an OBGYN.
It says any physician, that's why we call her Dr. Bender. She's a physician.
Okay, Judge Green, any other questions for Judge Isherwood?
Not this time.
Okay.
Thank you, Judge.
You're welcome. And Mr. Marino, since we peppered some questions to Mr. Prochaska there at the end, that caused him to go a little bit over. I'm going to still give him a couple minutes of rebuttal, but we'll give you some flexibility if you need to go over your 15 minutes. It's up to you. As Andy Reid would say, it's your time.
Thank you, Judge. May it please the court. The trial court's judgment as a matter of law in favor of Wesley should be affirmed because plaintiff is missing an essential element of their medical negligence claim, namely causation. As the court is aware, this claim focuses on the nurses reporting information to the physician and whether that report of information was complete. That is the claim of negligence, but no party is really disputing, as far as I can tell in the briefs or here today, that a link in the causal chain to establish whether that act is negligence is showing that the doctor who received that information would then turn around and order the Lasix, which is the treatment that the physicians testified would have saved the patient's life. Wesley acknowledges that there would be essentially two ways that that could have been accomplished through the evidence. Number one, Dr. Bender herself, the physician who received that report, could have testified, yeah, if I had received the complete information from the assessment, the complete information from the assessment that the nurse conducted at 7:15, that would have caused me, under the circumstances, to order Lasix. But that testimony is not in evidence. In fact, not only is it not in evidence, Dr. Bender affirmatively testified to the contrary. She testified when she did receive the 8:30 phone call, when Nurse Van Epps told her that the patient was experiencing respiratory distress, that she still needed to call and get the X-ray results. And why? Her testimony was because that's the piece of the puzzle that I was missing. That's the piece of the puzzle that I was missing. And the district judge picked up on this and pointed out that there was no doctor who testified in the entire trial who diagnosed pulmonary edema without first seeing the chest X-ray. Okay.
Well, let's talk about that a second, because it goes to Judge Green's question, and that is, it seems to me pretty clear that in order to establish their case, the plaintiffs had to not only show that the nurse deviated from the appropriate standard of care, which I don't think we're really talking about here. We're talking about, was there a causal link? What did a reasonable nurse have an expectation when she makes a report of, had she given all the information, what would a reasonable OBGYN do? And where it seems, where you got a little bit off course is in Judge Woolley's opinion, at least on page 15. He says, without, quote, without evidence on what Dr. Bender would have done or would have been required to do with the missing information. Would you agree with me that it's really not about what Dr. Bender would or wouldn't do? I mean, I tried both as an attorney and as a trial court judge, a lot of med-mal cases, and we're involved in a lot of med-mal cases. It's really not what Dr. Bender would do. Matter of fact, I wouldn't necessarily expect the co-defendant at one time to fall on the sword and say that, but they could establish it by that the appropriate, within a reasonable degree of medical certainty, an OBGYN would have been expected to give Lasix had they had this information.
I don't know if I necessarily agree with you there, because plaintiffs, Nurse Van Epps reported to Dr. Bender. This was Dr. Bender's patient. Dr. Bender was the resident.
But let's say Dr. Bender would have committed malpractice, and I'm not saying she did. But it seems to me that's not the question. The question is what the reasonable expectation would be. And the reasonable expectation would be that an OBGYN would do whatever the standard of care required for them if provided all the information. I know there's a lot of other things here, but I'm trying to really get to that link.
Yeah,
it seems to me that was really the missing link, not what Dr. Bender would or wouldn't have done.
So look, that is standard of care. And we acknowledge that that is the other way that the causal link could have been filled. Okay. So we're just trying, as the defense, trying to uphold the judgment of matter of law verdict. I think we've got to show you, one, that Dr. Bender, subjectively, there's no evidence that she would have done it. But also, we acknowledge we've got to show you that there's no objective evidence of what the standard of care would have required a physician in Dr. Bender's circumstances and Dr. Bender's position to do. I agree with you there. And there's also no evidence of that. And let's get to Dr. Savai's testimony first. So what we're looking at is page 115 and 16 of the transcript on Dr. Savai. And you really have to do some textual analysis here. Plaintiff's counsel engaged in it. Everybody's focusing on that. They call it the first question. Would you tell the jury if a resident in the third year is told about the symptoms of pulmonary edema, do they have enough knowledge at the third year to order Lasix? Think about that question. That's a foundation question for the standard of care question that is going to follow and does in fact follow. We also know it's a foundation question because the question before that is, Dr. Savai, don't you train residents? You can go back and look at the transcript. So he's building to the standard of care question that he wants to ask, right? Do you train residents? Do residents in the third year know enough if they hear about the symptoms of pulmonary edema to order Lasix? Dr. Savai then says, yes, they know enough. So he's responding to the foundation question, and he's given the plaintiff's counsel the foundation to ask the next question, which is that the standard of care? That the answer to that question does not come into evidence. Okay, the transcript has it ordered a certain way, and we point out that the transcript isn't always reliable on the order, but that doesn't matter. What really matters,
right? Well, let's talk about that a second, because that is a pretty fundamental question: is whether a contemporaneous objection was raised or the answer had already in. And I recognize in the real world, a court reporter is trying to take down when people talk over each other and whatever, but at least on the transcript, which we have to rely on as the official record, it looks like at least, I don't know if that was enough. I guess we'll have to make that decision, but it looks like that part was in the can. Well, they just wouldn't let them go on.
With the acknowledgement that sometimes people talk on each other and transcripts aren't perfect. What you need to understand is that the trial judge sustained the objection and ruled it out of evidence.
Well, what about ruled it out of evidence? He didn't strike it, or I did. At least I didn't see it. Maybe he did later, but I didn't see where he struck the testimony or instructed the jury to disregard
it. He sustained the objection, and then in the jury instructions, I can't remember which instruction it was, but it's the instruction that basically says you have heard me give rulings to objections at trial, and when I've ruled things, testimony out of evidence, you're to disregard that. So that was part of the instructions to the jury, standard set of instructions.
You'd agree this isn't a particularly procedurally, we wouldn't teach the procedures followed in this case in law school, would we?
Well, that's true for every trial. But
Well, let's talk about motions in limine real quick. You would agree with me that a motion or an order in limine is interlocutory in nature and can be reconsidered during the course of the trial outside the presence of the jury.
I agree with that.
Do we have an order in limine in this case other than, I'm looking at, all I could find is Defendant Wesley Medical Center's first motions in limine, August 8th, 2019, disposition granted by agreement. And then it goes on to talk about other things. How do we know? We're a court of, we have to rely on the record. How do we know what was to be excluded and not excluded?
Well, the evidence that is encompassed in Wesley's motion in limine number 1, number 2, and plaintiff's motion in limine number 1 were all agreed to. Okay.
Well, there's obvious disagreement on what it meant, at least from reading the briefs that both sides have submitted to us.
Well, there might be, but the judge made it clear what he considered it meant. And what he considered that it meant was that standard of care testimony concerning the former physician defendants. And that's one of the aspects that the court should keep in mind in this case. This is
Right, if Dr. Bender, but did he intend, and where is it in the record that he intended to prevent the reasonable standard care of any OBGYN if they were provided with adequate information in a timely manner?
Well, a ruling to that specificity was not made, but the ruling
because wasn't this your motion was hinted at, we don't want them bringing in standard of care evidence about the former defendants, or maybe some of them were still defendants at the time, but they ended up being former defendants. It wasn't talking about the generic standard of care that Judge Green was asking about of any physician or any OBGYN.
Well, sure.
Was it?
Yeah, Dr. Bender was a former defendant.
How could they possibly establish causation if they're not allowed to tell what a nurse who had reported sufficient information in a timely manner was expected that an OBGYN would do, a generic one, regardless of Dr. Bender?
Well, they wouldn't. That's our point. So
you're saying basically that they stipulated the case away before trial?
I don't think they realized that they did it, but I think that we had.
Did you file a motion for before trial saying we're done?
No.
If you truly believe that?
No, we filed we filed judgment as a matter of law at the conclusion of plaintiff's case.
What about beforehand?
If
you thought that's what the order in limine said, because those expert opinions could have gotten in.
Not beforehand.
If we follow what you're saying.
Remember, it's not just us that thought this way. The plaintiff's counsel also interpreted the court's orders and the parties' agreements beforehand to include exclusion of all standard of care opinions related to the former physician defendant.
Right, of the former physicians, I'm not talking about that. Let's take that out of play. I'm talking about generic OBGYN. What's their standard of care? That seems like it has to come into evidence in order to establish causation.
And well,
unless Dr. Bender fell on the sword and said,
a generic
hey, I messed up.
OBGYN, I believe that your question probably goes to foreseeability, because there is no such thing as a generic OBGYN, right? So what you're asking.
Well, there is a such thing as a standard of care that would be accepted by any OBGYN acting within a reasonable degree of medical probability.
Well, sure. But remember, if
you're saying they couldn't, that because they stipulated to this order in limine, they couldn't bring that in.
Well, because of the 3 orders in limine and the party stipulation beforehand, yes, that's true. And plaintiff also recognized that. Plaintiff's counsel objected when we tried to ask standard of care opinion concerning Dr. Eddy.
Well, again, that's a specific, you're mixing apples and oranges here. That's a specific doctor. I understand why they wouldn't want to do that, because that's whether then you're going to compare the fault of the former defendants. That's not what we're talking about in this case. Of course, that comes up all the time in a
But if,
mental case where
but if
somebody
Dr.
settles.
Sabai's, I'm sorry, if Dr. Sabai's opinion concerning Dr. Bender's standard of care comes into evidence, then Dr. Bender goes on the fault line. Remember that. And that's what plaintiff wants to avoid. Dr. Bender goes on the fault line. If Dr. Sabai's testimony that we're talking about comes into evidence, Dr. Bender goes on the fault line because Nurse Van Epps testified that she gave a full report at 7:15.
Let's say we disagree with the judge's order. Let's get to the remedies here. I take it your argument is if we did reinstate the judgment, it would be at the lower amount as reduced by the judge, but that if we do not reinstate the judgment, but still decide in favor of the appellant, that the appropriate remedy would be a new trial?
That's right. So if the court disagrees with us and thinks that Dr. Sabai's testimony should have come into evidence on standard of care, the remedy has to be a new trial. And that's not a remedy that we're asking for. Plaintiff is trying to reframe the remedy question because we are the victors in the district court. We have judgment in our favor as things stand. Plaintiff is the appellant and the party asking for a remedy. The remedy we want is an affirmation. The remedy plaintiff wants is the issue before you if you believe Dr. Sabai's testimony should have come in. The two, and really, I would submit to the panel that the only proper remedy would be a new trial, because if Dr. Sabai's testimony didn't come into evidence, then judgment as a matter of law was appropriate. And if Dr. Sabai's testimony did not come into evidence, then and it was error, then plaintiffs are entitled to a new trial. That's pretty much Hornbook law as far as I can tell. This idea that you can reinstate the verdict without Dr. Sabai's testimony doesn't make sense to me.
Any questions from our other panel members? Okay, I'll give you a couple. You're at your 15 minutes, but I'll give you a minute or so to wrap up.
I'm sorry. The other thing, Your Honor, is Dr. Bender would need to go on the verdict form if we have a new trial and that testimony comes in.
Well, that issue is not before us right now. Speaking of issues, it's not before us. Is the issue of caps and constitutionality of caps or anything before us other than what the Supreme Court's already done?
We did not appeal the caps.
Anything else, then, counsel?
I think that the court should also uphold the verdict because Dr. Sabai, the testimony that he would have given regarding standard of care applicable to Dr. Bender was a new opinion, not in his report. And I understand the part where he says treatment would have been started if complete information had been conveyed by Nurse Van Epps. There's two things wrong with that paragraph, though, in the report. Number one, it's in the context of Dr. Sabai having already said Dr. Eddy should have ordered a chest x-ray at 5:30, and that chest x-ray would have led to Lasix being given. So remember, he's assuming a chain of events where Dr. Eddy should have ordered a chest x-ray, should have ordered Lasix. In fact, the only point in his report where he talks about ordering Lasix is in connection with Dr. Eddy's failure to order a chest x-ray. What he says in connection with Nurse Van Epps' failure to report complete information is this generic opinion that it would have led to treatment. I want to refer this panel to the Supreme Court's opinion in the Druhard case. It's 301 Kansas Reporter at page 624. There, the expert, it's the same kind of case. You've seen the Druhard case in the briefing where it's basically a radiologist who they claim misread an x-ray, but no physician ever looked at the x-ray or the radiologist report. And so it was just kind of negligence in the air. There was no causal link. In that case, an expert had said that a correct diagnosis would have resulted in a stat ultrasound or HIDA scan when Mr. Druhard was in stable condition. An appropriate life-saving intervention should then have been administered. That phrase, appropriate and life-saving intervention, the Kansas Supreme Court said that was too speculative and was inadequate to establish causation. Here's the quote from the Court of Appeals, or from the Supreme Court opinion. The references to life-saving intervention, quote, and emergency surgery, quote, are speculative without some additional facts or details regarding those treatments and their potential outcomes. Dr. Sabai's opinion that it just would have led to some generic treatment if Nurse Van Epps had reported complete information is similarly inadequate, as stated by the Druhard case.
But here, of course, we do have a specific Lasix that could
But
be
not
ordered,
enough
if there's
to-
enough there. You're saying that there was not enough in the report
Yes,
to get to that.
yes.
Well, now you're about up to 18 minutes, so we better wrap this part of it up. But I want to make sure Judge Green and Judge Isherwood have a chance here if they have any questions.
I just have one question. As far as your objection, excuse me, I see where the plaintiff said that wasn't good enough. That was not a specific objection under 6404. What do you have to say to that?
Well, that's not what he said at the time, and it's in our briefing. What he thought he argued as if it was an objection at the time. He said, no, that's not standard of care, it's causation, because he knows that standard of care opinions are out. He also later says, when he's arguing the judgment as a matter of law motion, he acknowledges that the judge wouldn't let him get into it and that an objection was lodged. So at the time, when the parties are actually in the heat of the moment in trial, plaintiff's counsel well understood and acknowledged that there had been an objection and that testimony was kept out of evidence. That would be my response.
Any other questions? Okay, hearing none. Thank you, Mr. Marino. Back to Mr. Prochaska, and I'll go ahead and give you a couple minutes to respond to some of this.
I'm going to try and respond briefly to 4 points. First of all, excuse me isn't an objection to specify what the objection is about. The only objection came from the trial court, which is, again, error. Trial court shouldn't be trying the defendant's case. Second of all, their comment that nobody gave Lasix until there was a chest x-ray. Well, that's true because nobody was given a full report. That's why there was never a full report. I've waited 2.5 years for the defense to show us this full report. They sure didn't do it during their argument in front of the appellate court. It's because it's non-existent and a horrendous error to base throwing a verdict out by the trial court. Furthermore, this business that the trial court said about, I'm going to quote this. This is the trial court, volume 3, page 22. Quote, no one asked Dr. Bender what she would have done, what she could have done. Well, that's because it's irrelevant. And Judge Bruns, you hit it right on the spot. You could call Dr. Bender to the courtroom and she could say, you know what? If you gave me the fullest report ever and talked about that fluid overload, I would have never given that Lasix. And the jury, who is the fact finder and the weigher of the credibility of the evidence, not the trial court, the jury could say, you know, Dr. Bender, we don't believe a word you're saying. Just like Judge Bruns said, you're probably just covering for the hospital and for the nurse. We don't buy a single word you said.
I probably should note I did not say that.
Well, you can know. I'm embellishing it.
That's the inference. Okay.
Yes.
That you took.
So there's no law saying you got to hear from her, and it's speculation. It was irrelevant. Also, on this standard of care stuff, we didn't say standard of care because, or Dr. Abai in his report didn't say this. He said the standard of care required giving the Lasix. He never said that she committed a deviation by not giving it. How could she possibly commit a deviation if she didn't get the full report? And he never commented on it being a deviation. His sole point to the standard of care testimony is it goes to causation, not whether she fell below the standard of care. That phrase, whether she fell below the standard of care, is not in his testimony. It's not in his testimony for a reason. No plaintiff's lawyer with any brains would ever want to fault a non-party. And the defendant, who's somehow wanting a new trial for that, stipulated they will not fault anybody comparatively. That's a stipulation. The trial court erroneously thought it went to standard of care called deviation, didn't allow our causation opinion in, but the trial court correctly didn't allow Wesley Hospital to try and fault the non-party after they stipulated that they wouldn't fault it. And Dr. Bender Dr. Sabai didn't even open that door at all because he didn't have deviation in his answer. So lastly, Drew Hard, they didn't even have a treatment that would work. And they didn't even know if it would work anyhow. Drew Hard is so different and so distinguished. I think you, Judge, caught on to that. So the bottom line is we prevailed on the inferences and the facts first. We prevailed again all over again on the standard of care testimony that was not motion to strike. It wasn't, the jury wasn't admonished to disregard. That jury instruction, you can't use that for every single case to say you don't have to admonish the jury to disregard. So the evidence and the issues were decided. There is no reason for a new trial. The only reason they want a new trial is because they know they lost on all of the issues. Can we have a do-over, please? So I will repeat my urgent request to the appellate court. If you give a new trial or decide this in favor of the defense, you have just destroyed the jury system in Kansas, because you cannot give a new verdict based on these humongous, obvious errors of the trial court.
Questions from the panel?
No.
Well, thank you both. Good arguments, and we appreciate the briefing in this case. We will take this case under advisement and try to get an opinion out to you as quickly as we can.
Thank you, Judge.
Thank you all.
Thank you, judges.
Well, good morning and welcome to the second case on our November docket. For those who don't know me, my name is Judge David Bruns. It's been my pleasure to serve on the Court of Appeals now for about 10 years. And I'm honored to be serving today with the Honorable Judge Henry Green, who is the longest serving member of our court, who joined us in 1993. And then one of the newest judges on the Kansas Court of Appeals, who just joined us this year, earlier this year, Judge Leslie Isherwood, after an illustrious career with the Sedgwick County District Attorney's Office. So we appreciate counsel bearing with us. As I've indicated, my computer is making some noises, so bear with us on that, and I apologize for that. Both of you are experienced counsel, so you know that each side has 15 minutes. This case is a criminal case, State of Kansas versus Hamilton. And well, I'll ask you to go ahead and state your appearances, if you would.
May it please the court, Patrick Dunn, Deputy Appellate Defender, here today on behalf of Kashawn Hamilton. And could I have 3 minutes for rebuttal, please?
You may.
May it please the court, the State appears by Assistant Solicitor General Natalie Chalmers.
Thank you both. And with that, Mr. Dunn, you may proceed.
Good morning. Just a quick, this is my first time with Judge Isherwood not sitting across from me, across the table from me, yet on the other side of the bench. So nice to see you and congratulations. So on the night of July 1st, 2018, police were called to the apartment of Christopher Hanser, where he and Sarah Newper claimed that Hanser had been battered, Hanser's apartment had been burglarized, and both had been robbed. They both claimed the perpetrator was Mr. Hamilton. Now, ultimately, the state charged Mr. Hamilton as a result with the aggravated burglary of Hanser's apartment, the aggravated battery of Hanser, and the aggravated robbery of both Hanser and Newper. The jury, however, did not convict on the aggravated robbery of Newper, but convicted on the remaining charges. So there really were two primary issues at trial. And the first was whether Newper had been in on the alleged incident that happened. And the second was because Ms. Newper had had a relationship with Mr. Hamilton. It was a whole complex affair between three parties of things that had happened in the past as former neighbors, and kind of a triangle, I suppose. The second issue was whether Mr. Hamilton had been the actual perpetrator at all, as he presented an alibi defense at trial. Ultimately, some of the jurors believed that Newper had been in on it. And we know this because they hung on the aggravated robbery charge of her. However, at the same time, it did not believe Mr. Hamilton's alibi defense. And we know this because it obviously convicted him of the remaining charges. And although relevant, and I'm not going to be talking about it, the district court at sentencing made a deadly weapon finding and imposed a 15-year registration requirement. So at the outset, I want to do a little housekeeping. Today, I really only intend to talk about issues 1 and 2. The state conceded issue 3, and I believe a nunc-pro-tunc has been filed below, resolving the jail credit issue. And then issues 4, 5, and 6, while we maintain that our Supreme Court was wrong in its decisions, I believe there has been authority on those, and we're not going to ask you to do what you can't do. So we're going to submit them on the brief and preserve those issues for further review. With that, go ahead and move into the first issue, which is a prosecutorial error issue involving the state asking questions and kind of proceeding on a strategy without a good faith basis for doing these things. It's important to understand that the only evidence tying Mr. Hamilton to being present at the Hanser apartment that night, the night of July 1st, 2018, was the testimony of Hanser and Newper. That testimony, however, was contradicted by Mr. Hamilton's alibi, Jessica Roseman, who testified she picked him up from a Hope and Faith Assisted Center, which is some kind of mission, basically, in Kansas City, Missouri, on either the night of June 30th or July 1st, and that he remained with her and her family until July 5th. And during that entire time, he was helping get ready for a big family reunion 4th of July party. So we don't have any physical evidence tying Mr. Hamilton to the scene. So that's important because this was not a case of overwhelming evidence where that these sorts of things wouldn't have made any impact whatsoever. The state in its brief kind of distills things down to a couple points of errors, but then at the same time says they're not sure what our argument is. So I want to go ahead and break it down a little further. There are two real problems we're talking about in this issue. First was the overriding problem that the state, despite we believe not having any reason to believe otherwise, attempted to imply that defense counsel checked out Mr. Hamilton's cell phone from property at the jail in an attempt to hide evidence from the jury. And the state, of course, they never explicitly said that was their strategy. However, defense counsel explicitly said that's why we're having these problems and pointed it out, and the state didn't disagree. Really, the big problem was on rebuttal after the alibi witness, we had the state bringing in the detective who on November 1st, which was 6 days before, had found out that defense counsel had properly checked out the phone and made no attempt whatsoever to obtain that phone or find anything. But yet still, there was really no, I'm sorry.
Mr. Dunn, isn't that just standard rebuttal testimony? I mean, what is your authority for that actually being erroneous?
There needs to be a good faith basis for the question. And
well,
it has
doesn't the state have that by the fact that he was in Topeka at Miss Nupler's assistance? I mean, she brought him the ticket that was on her cell phone. I mean, she has a good faith basis for believing he's there. So I'm first not understanding why you think that there's not a good faith basis, and then why that rebuttal testimony is erroneous.
Well, I think it's important to remember that this is Mr. Hamilton's cell phone had no service. It was only the only way it could be used was with Wi-Fi. There's never any evidence that that phone was in any way used where there was Wi-Fi on the date of July 1st. And the state even acknowledged this when they were having this argument. The prosecutor said, well, we're not sure if it pinged or not. So basically they're taking stabs at the dark. If they really had a good faith basis for thinking there was evidence on this phone, they would have sometime during that 6-day period given a call to defense counsel, which they admitted that Hayden admitted he made no effort to do this. There was no effort whatsoever. This was just an attempt to kind of throw a smoke screen up to make it look like something was afoot, that defense counsel was somehow sneaking something away from the jury and hiding something. And there was no good faith basis to think that that was the case.
Well, counsel, you would agree that his location during the time that the crime was committed was at least material to this case in light of his alibi.
Certainly. I don't dispute that at all.
And didn't Judge Parrish limit what could be brought in to try to protect the defendant? She, a matter of fact, sustained the objection when the state wanted to go on and to go further than that. I mean, I don't see how it's inherently an error, much less prejudicial, to simply ask a defendant, hey, is there anything on your cell phone? You filed an alibi defense. Is there anything on your cell phone that might show you were in Topeka? Seems like a legitimate question.
That was outside.
And we can infer why they asked the question, but let's say there was no evidence about it being checked out. Seems like that's a pretty good question in any case.
Sure, if there hadn't been any restrictions on anything, and if at the time when Mr. Hamilton agreed to testify, and again, we're talking about a criminal defendant, not a lawyer here, he specifically said they can't just go, I don't want them just running amok, being able to ask whatever they want. They're only going to be limited to questions about the phone, right? And this was a discussion between Judge Parrish and defense counsel, and I think at that point, the secondary defense counsel that by then had been called in. I mean, again, I'd point out there seems to be a little bad faith when everyone agrees initially, oh, we're just going to let defense counsel get up and say this if you bring another attorney in. Then, oh, we're going to change our mind because we're going to do everything we can to keep the defense from being able to explain what's really going on. That it's not some sort of mysterious plot to hide something from the jury. State said, okay, yeah, we'll let you bring in counsel from your office. Counsel from your office then gets there and says, no, now we're going to ask for a mistrial. That wasn't brought up before. So it seems a little bit bad faith to get to that point in and of itself there. We then get to the point of where Mr. Hamilton says, they're going back and forth. How are we going to get this in? Oh, we don't know who the jailer was to talk to. And we're not going to be able to get them in because the jailer that the state called wasn't the same person that defense counsel had checked the phone out from. That was convenient there. So we're stuck with that kind of no-win situation where, oh, it's a mistrial, which it's questionable whether Judge Parrish was even correct, because this seemed to be a situation where there would be substantial hardship to the defendant, and we're not looking at anything that really is going to expose any privileged communication, nor any privileged communication that couldn't have been waived with informed consent under Rule 17. I think people were proceeding under a misunderstanding of the rules of professional conduct on this particular aspect in and of itself there. Nevertheless, Mr. Hamilton's, hey, I got to do something. Hey, what if I testify just to the fact that she only was getting the phone to get those phone numbers?
You didn't want to hear the buzzing noise. Just so you know, you're at about 10 minutes, so you might want to move on to your other issues to make sure you get those in.
Okay. I want to be sure I cover. Let me take a quick look, be sure I covered everything. We believe there was no real good faith basis on this. This was all an attempt to bring something that shouldn't have come in. And they knew the state really didn't have any reason to believe defense counsel had done anything wrong. And so moving into issue 2, with diluting the burden of proof, during voir dire, the state went through some of the standard types of arguments when you're talking about reasonable doubt, trying to say it's not beyond all doubt, and then kind of bungled here, I'd say, its analogies. Typically, the types of analogies the state we're talking about are what are used for circumstantial evidence. You have a kid, you're trying to figure out, one of the kids took a cookie from the cookie jar, but then they moved into this second analogy, which is it just totally blew. The analogy normally is there's snow on the ground. When you wake up in the morning, there was none the night before. It had to have gotten there. And, you know, we're not in Colorado where you live next to Keystone or Vail, and there was a snow machine that could have turned on. In Kansas, it's reasonable to think that that was circumstantial evidence that it snowed right before. State, however, said it's wet. And one veneerman said, yeah, it could have rained. But then another said, wait a minute, it also could have been rain, snow, something else. And the state even says, yeah, I guess it could have been fog too, realizing they kind of messed thing up.
Well, it seems like maybe the jury corrected this mistake.
They did, and I don't think we would have had a problem, but yet the state came back to it in closing argument, and that's where the problem comes in, because the state returns to this flawed analogy, and with it, it's dry outside, you go to sleep, you wake up, it's wet everywhere, probably rained. And again, probably is not the standard we're looking at. Common sense isn't the standard we're looking at. Beyond a reasonable doubt is the standard we're looking at. We contend that this diluted the burden of proof, and this error was error in and of itself when we come down to when this really was a who do you believe situation, not a physical evidence situation, and therefore it's prejudicial. We also contend when you take this in conjunction with what we believe to have been error in the first issue, that both of these combined require reversal. So I try to speed up. Now I don't know how.
Well, you're a little over your 12.
Okay.
Over your 12 minutes, but you know, we'll be flexible with both you and Ms. Chalmers. So are there any questions from the panel? I want to make sure, since I was new, I want to make sure.
All right, and I'd go ahead and let the state have their piece. Thank you.
Okay, well, then we'll reserve you some time then for rebuttal. Ms. Chalmers?
Thank you, Your Honor. The bad faith in this case seems to be not giving decent notice of an alibi. The statute requires notice 7 days prior to trial. We got it the day of trial. We did the best we could with that, and we didn't do anything in bad faith. Of course, defense counsel did exactly what we predicted they were going to do. And they argued we didn't do a good investigation. We should have investigated more. The detective tried to explain that he had 2 witnesses, and then also, along with the 2 victims in this case, there was another witness named Leon Weirick, I'm going to say his last name, probably slaughter it, that was there that didn't testify. So all that rebuttal was trying to explain, well, we didn't do this earlier because we didn't have notice of the alibi. And then we got notice of the alibi to go look at the phone had been checked out. But both witnesses testified the phone was checked out properly. There was nothing to miss with the phone being checked out, and that they just didn't go to defense counsel. Well, the detective didn't go to defense counsel to try and get the phone. At that point, as the prosecutor commented when this whole thing was happening, he didn't understand why defense counsel needed to testify at all. But I cannot fathom how the prosecutor, just trying to keep defense counsel from having a conflict of interest in a case, is somehow malfeasance by the prosecution. I'll admit we originally were like, yeah, defense counsel can testify to that, but probably what happened, I don't know, is they gave it a little more thought, and then we're like, wait, what about the potential conflict of interest? And then the judge too thought there was a conflict of interest. That's a reasonable thing to a prosecutor to do. We don't have to risk our jury conviction when there is a potential conflict of interest. And then the question asked is, again, I don't want to totally write the 1507 for defense counsel if we win, but was defense counsel's problem? Defense counsel asked a broad question. Defense counsel didn't ask, hey, did I check out this phone to get contact information for some witnesses? She asked, did it have anything useful? I think, as Judge Bruns pointed out, it was a reasonable question for prosecutor even before that to be like, oh, you have a phone, you have an alibi witness. Is there anything on the phone that's relevant to that alibi? We asked the question, it got sustained. I'm not entirely in agreement with the sustained, but at that point, there's no evidence in front of the jury. The jury can't convict based on a lack of evidence. That violates a jury instruction that they're given, that they are presumed to follow. So it's the state's contention that there is absolutely no error in this case. And I know for the first time today, anyway, defendant says that, well, there wasn't really a conflict. They could have testified. Well, that issue has not been briefed on how there wasn't there wasn't a conflict. And I think under the professional rule of conduct 3.7, there probably was a conflict. Or well, we stand behind there being a conflict, but regardless, Hamilton hasn't briefed how there wasn't.
Well, this
So
case,
sorry.
counsel, this case doesn't really hinge on whether there was an extra conflict, whether there was a good faith belief that there could be a conflict.
Right. And I
That's
think
why the
that's-
issue was raised.
Right. And I think that we absolutely had a good faith belief that there was a potential conflict. And then they tried to work that out. And then the way they fixed it was Hamilton was going to get on the stand and be asked a few questions. And then again, defense counsel asked a weirdly broad question. And I think the prosecutor asked a reasonable question, especially since we know he was in Topeka on July 1st of 2018. And there was evidence that he used a bus ticket, which he presumably got on his phone, in order to get there. So we know that there's evidence on that phone. I don't understand how that question does not have a good faith basis. But even if there was some potential error, again, the error here has to have been harmless because the jury could not have used the non-existence of evidence to convict. I don't really think I have much to add to my second issue beyond what's on the brief, unless this court has questions. So if there aren't any questions, I would just respectfully ask that the convictions in this case be affirmed.
Does any of the panel members have any questions? Well, thank you. And back to Mr. Dunn for rebuttal.
Thank you.
Okay, first of all, I understand the state is grumpy about finding out about the alibi on the Friday before trial. However, if we look at 2232.18.2, we see that this is a discretionary decision by the judge on whether to allow these witnesses. And as I'm sure counsel would be arguing against me in any other abuse of discretion case, that's not a very good standard to have to review. So I'm afraid that that was the judge's discretion, and there's not a problem with that at this point. Now, the state also mentions this Leon character, and I may be misremembering the record, but I don't believe it was clear that he was available as a witness. I believe it was discussed that there was someone present named Leon, but I don't think it was ever clear that he was subpoenaed and there and ready to testify. But the record will bear out whether or not that was the case. Next, again, I guess I got to return to why these rebuttal witnesses were called at all. Because if they're called to say that the phone was checked out correctly, then I'm not really sure how that's relevant to the state's case at all. What's it matter if the phone was checked out and checked out correctly? How does that prove the state's case in any way? What material fact does it show? So that makes us come to the fact of why is it relevant? Why is it proper rebuttal evidence at all then? And the answer is because the state wanted to let the jury bring this jury to this inference that there was something amiss. And while the state says, yeah, there was no evidence, the thing is juries can make inferences, as Judge Perez pointed out, because defense counsel tried to say, this isn't a contested issue. We all, everyone knows why I went and got the phone. It's clear. I went just to get these phone numbers to try and because there were actually two alibi witnesses. Facebook Messenger was the initial contact, and counsel even stated I didn't initially bring this alibi defense because I didn't know if these were real, and I didn't think I had a good faith basis to bring it unless I did all the necessary investigation. And unfortunately, the investigation didn't come up until the 11th hour. But when counsel kept trying to say there is nothing contested here, which is also an exception under the rule 3.7 of the model rules, to where a lawyer can be a witness, Judge Perez said, well, I guess it is contested because it's brought up at all. And so if it is contested, then it seems like necessarily there has to be some of this no evidence being there at all that is before the jury. Everyone recognized that there could be arguments made to the jury on this. So it is something that the jury could have thought about and could have listened about. And I'm going to acknowledge the question was not great. Defense counsel certainly could have made a much narrower question. And frankly, it may be the grounds for Mr. Hamilton's 1507 later. I think that was pretty obvious to everybody that it was a poor question. However, everyone knew the only reason Mr. Hamilton was up there. I don't think there was any question that defense was trying to get anything else in or was trying to open it up. 2 additional questions by the state. So I think it was a less than good faith effort there when everyone knew what it was, when the state intentionally tried to go beyond what defense counsel and Mr. Hamilton believed the only thing that was going to happen and be questioned about was on the stand there. So unless there are any further questions, I would ask the court to reverse based upon full error.
Are there any other questions from the panel? Seeing none, thank you both. Good arguments and good briefs. We will take this case under advisement and get a opinion out to you as quickly as we can. Thank you all.